going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Thursday. I've got it. Eric Martin back in front of Judge Washington. Oh, and it's good. It does not disappoint. Same old arguments. Plus, he brings a new one. And it's shocking. Can't believe he said this. Anyways, McDuffie is... Yeah, anyway, let's go. Let's go. Before I hit that play button, you already know what to do. Hit the like and subscribe to your Jump Kicks Backflips. Let's go.
Mr. Eric Martin, please unmute your device, and state your name.
Can you hear me?
I can now, sir.
Capital E, lowercase R-I-C, of the capital M, lowercase A-R-T-I-N family, a living sovereign, one of the people.
Assistant Public Defender Davi Lebo as standby counsel.
Thank you. We're here for a pretrial today, and a bench warrant is still outstanding for Mr. Martin.
That's correct, Your Honor. As it relates to the pretrial, I believe the last time that we saw Mr. Martin, it was on December 7th, and he had some difficulty viewing the video that we had sent via flash drive. I encouraged him to get with his standby counsel, who at that time was APD Sandra White. He did not appear at that next hearing, but she did confirm that they had spoken almost every day and that they had reviewed the video. So my understanding is that Mr. Martin has been able to view the complete discovery, including all of the media. I know that we were headed to a jury trial, so I will leave it to Mr. Martin to confirm that so we can get going with selection.
Mr. Martin?
All right, before we hear from the alphabet man, M-A-R-T-I-N family guy, a little backstory. So Eric Martin, it was about a month ago, decided not to show up for Judge Washington's in-person hearing. Also, he had a hearing in front of Judge Slavin that exact same week. You know what he did? He showed up, but then got tired of waiting and left. So he had a bench warrant out of Ypsilanti and out of Taylor. And he lives right smack dab in the middle of both of them. At least he said. He said it in front of Magistrate Braley, I believe. So he's doing well. He's batting 1,000 for sure.
Yeah, I looked at the video, and I looked at the video, and I also filed some demands to dismiss, some self-incrimination based on the video, along with some others that have not been decided on, which should be decided on before any trial scheduled or anything else.
Mr. Martin, I've decided on all the motions that you've brought before me. And the way this works is if I make a motion ruling, then the party making that motion has to prepare the order. So when you complain about no orders being prepared, that's your not preparing them, sir.
What do you mean not prepared?
I think my words were very clear.
I understand what you're saying. You're saying because I didn't file it as a motion or something? What are you saying?
I'm saying that I already ruled on them. So when I rule on them, it's up to the party to prepare them. That's you.
I did prepare them. Specifically, my demand to dismiss.
Sir, you did not prepare my ruling order, which was that they are denied.
What do you mean they're denied, but you didn't rule on it? How does that happen?
Do you have anything else? Yes, Ms. McDuffie.
I'm sorry, Your Honor. I did just want to clarify one point because Mr. Martin, I think, mentioned that he wanted to move to dismiss based on incriminating statements after he had reviewed the video. So I don't know if there's a sort of Miranda issue he's raising or not. But I would just, I guess for the record, remind Mr. Martin that when he appeared for the hearing on the 5 documents that he filed, demands, motions, whatever you want to call those, Mr. Martin, during that hearing, rattled off the fact that he did not have a valid license, his vehicle wasn't registered, and he didn't have insurance and didn't feel like he needed to do any of those things. So if there are any incriminating statements that would relate to the counts in this case, he has made them multiple times, including on the record in this court at his own hearing. So if any statements were suppressed from that media, they would still come in from statements he's made in court.
Well, I object to the third one is self-incriminating. As I pointed out and stated in my demand to dismiss, as the U.S. Supreme Court said, license ain't necessary. We're not using the streets for profit, which the cops have no evidence.
Mr. Martin, you're going to need to speak up if you want to have a transcript of this, because it's not.
Mr. Martin has had audio issues for quite some time. And yeah, I know. It's not on me, though. It's on him. But I'm glad he got called out for it. Judge Slavin called him out a few weeks ago for the exact same thing. Anyways, this is why you don't talk. Prosecutors listen. She heard you say that. Yeah, maybe he stated he didn't have a license or registration or insurance before he was Mirandized. Then that couldn't be used in court. Unfortunately, he said it in court on the record. Prosecutors listen. This is why you don't talk. Don't talk. You might just walk.
I'm speaking up.
Let's see, Heather. Okay. Can you bring the microphone closer to you, Mr. Martin?
Yeah, let me see.
I'm sorry.
Kind of a little closer now. How's that?
Is that any better?
How's that?
How's that? Yeah, please keep talking in the same volume that you're using right now so we can hear it.
Well, I object to what she just said about I made some self-incriminating statements. That's not true, because as I pointed out in my demands to dismiss, the law is in my favor, the higher supreme law, such as the statute, which is supreme law of the land under Article 6 of the U.S. Constitution. Federal statutes override state statutes, along with the Packer versus Banton case I cited and sent a quote from the law book on that clearly said from the U.S. Supreme Court that the people have a right to use the roads, not a privileged right. And as long as you're not using the streets for profit, which I wasn't doing, and there was no evidence, and the cops have no evidence of that. So I was exercising my right to travel, didn't need a license, insurance, registration, none of that. So nothing self-incriminating about what I say. There's no legit case here. And which is why I beat a case on the same exact issue in Southgate. Same exact issue. Prosecutor moved to dismiss it because they know they had to win the case. The higher law is in my favor. The state law is unconstitutional. That's assuming everyone's driving a motor vehicle when they're not. And I'm working to change that state law, and I'm going to. I already got a federal lawsuit filed on it in the Detroit courthouse on Lafayette Boulevard. Right now I got to fight one about filing fees, but when I overcome that, they'll be deciding on the merits, and I will be winning on that issue, and the state law will be changed. It's going to stop making the presumption, the state statute law, that everyone's driving a motor vehicle, even when it's not for profit. That's the problem with the state law. It's unconstitutional. Cops are blindly following that, acting as if that, and then the so-called courts are acting on that presumption. No, everyone's driving a motor vehicle. They need a license, insurance. So no, they don't. They're not doing it for profit. They're exercising the right to travel.
So, Your Honor, since Mr. I'm sorry, Mr. Martin. Since Mr. Martin has again made those same statements that I referred to earlier, and this prosecutor will not be dismissing anything in this case, we will be proceeding to trial if he doesn't want to plead to it. Let me ask the court if I could. Are we ready to set this? I understand he has a desire to file an endless amount of lawsuits and grievances and motions, but the court has indicated we are past that point. Are we ready to set this case for jury selection or no?
Yes, we are.
Thank you.
All right, any motion that was just made, whatever he's entitling that, is denied.
So you deny something, you don't even know what it is. But anyways, you still have, there's still demands to dismiss that haven't been ruled on as a matter of law. which what a lot of them are, such as the state as a party. I filed a demand to dismiss because the state is the party here. Plaintiff. The state in this court, so-called court, has no jurisdiction, as indicated, as I indicated in my demand under the U.S. Constitution. Only the
Sir,
U.S.
sir, I'm not hearing those motions again. On October 26th, I made a ruling on all of those motions, and you have not prepared the order to that effect. We're done with those motions.
It's in order.
Is that the
So-
May jury selection, Your Honor? Or
No, it's
June?
not. We're gonna do a July 25th July 25th final settlement conference.
Okay.
And August 9th. Jury
Right.
selection.
July 25th, 2024.
Hold on, let me write this down here.
Hold on 1 second. 1 second, please.
All right, I think I have about 10 seconds before Mr. Martin speaks up again. But
And
yeah,
I'm also going to make a demand
Ah.
right now for compensation also for this making me proceed against my will under threat and duress to these so-called court proceedings in violation of my 13th Amendment right against slavery. All these court proceedings are against my right against slavery.
all right. Did you see McDuffie's reaction and also Judge Washington's reaction? They both just looked at him like, what? What? All right, that's a new one. I've never heard a sovcit say that. I'm not even going to repeat that word as I don't want to violate anything from, the TOS. So, man. What? All right. Let's go.
So I'm entitled to compensation for all the court proceedings that I had to make in this case. Otherwise, I would have possibly been arrested. So it was only under threat and duress. It wasn't by consent willingly.
Mr. Martin knows that the jury selection is in person, correct?
I haven't finished telling him all of that yet. I'm getting the dates. I'm going
Okay.
to tell him in just 1 second.
Mhm.
All right.
All right, that was McDuffie's way of saying you need to stop talking now before I get angry with you. This is great. All right, I'm going to let this video play out. There's only a couple minutes left of this. You guys are awesome. I do want to show you something because I don't want to pause it again. Once this is over and once Judge Washington literally kicks this guy out of a room here in about a minute and a half, watch the smile on APA McDuffie's face. Just do it. All right, you guys are awesome. I'll see you guys in a little bit. Have a good day. Till next time. Bye.
The final settlement conference in this case is going to be on July 25th, 2024 at 11 a.m. And that is on Zoom. The August 9th jury selection is in person, and that's at 8:30 a.m. on August 9th.
Hold on. July 25th, 24, right? 8 p.m. a.m. You said, right?
It's at 11 a.m., sir.
I want to be understood. I'm not willingly giving up my right to be one of the sovereign people and by this jury, but
Jury selection is August 9th, 2024 at 8:30 a.m.
You said 24th?
It's at 8:30 a.m. I meant to say 8:30 a.m.
You said the 24th now, or you say the 25th?
August 9th, 2024 at 8:30 a.m. is the jury selection, sir.
I thought you just said 7/25/24.
That is the final settlement conference. That is on Zoom.
Hold on, I got one thing at a time.
Numbers are hard. Numbers are real
Okay,
hard.
now let's do the what's the other date now? August. What else?
August 9th
Okay.
at
What time?
8:30.
8:30, and what's that considered? What's that called there?
Jury selection, sir.
Now, which is in person here now? The 7/25/24, is that something I have to be there in person for? I'm being
For the fourth
threatened to come
time,
up
Mr.
there.
Martin, please listen. The first event, which is in July, is on Zoom. The last event is in person.
So we got it. So we're saying a whole bunch of wonders, you know.
All right, we're
Yeah,
done today. Have a good day, Mr. Martin. Bye-bye. The court will call the case of the state of Michigan versus Maurice Jordan.